Hi, my name is Jamie DeSimone, and this is my state law case presentation for the St. Petersburg College, the course ATE 3515, Law and Ethics of the Veterinary Profession. This case that we're going to talk about today was titled People versus Suzanna Savedra Youngblood. It was seen in California, the Court of Appeal, 3rd District. 109 California Reporter, 2nd District 776, overseen by Judge Nicholson on Monday, July 30th, 2001. We will start with the facts of this case. On December 31st, 1998, Officer Robert Carter of Placer County, California, Animal Control, responded to a complaint that an excessive number of cats were being kept in poor health and living conditions inside a small trailer. When the officer arrived, he noticed a 7.5-foot by 11-foot trailer near the garage of the home. As he approached it, he smelled a strong odor of ammonia, which he associated to be animal urine. The owner of the property, Terrence Devaney, responded to Officer Carter when he knocked on the door. Devaney told Officer Carter the trailer belonged to the defendant, Suzanna Savedra Youngblood, who was not home at that moment. Officer Carter looked through the window of the trailer and observed, at least in his opinion, 35 cats living among fecal matter and urine. He also noted that many of the cats were sneezing and had eye discharge. Officer Carter immediately obtained a search warrant for the trailer and called for the trailer to be towed to the DeWitt Center so it could be placed in a building before being opened to prevent loss of control of the cats. As the trailer was being towed, the defendant arrived at the property. She claimed that she had been caring for the cats and also said that she was medicating them. She offered a medication vial to Officer Carter, who would not accept it because it was not adequately marked from a veterinarian. The defendant estimated that there were between 80 and 90 cats inside of the trailer. She later testified that at the time the trailer was seized, she was living in Sacramento County and began rescuing the cats, about 35 to 40 at a time, and placing them inside the trailer. She then moved the trailer to the Devaney property in Placer County after she was warned by Sacramento animal control officials she was not allowed to own more than 4 cats. At first, she says she was living either in the trailer or in a tent next to the trailer, feeding, cleaning up after, and caring for the cats. Then she says that she moved back to Sacramento County, but continued to visit the trailer and care for the cats regularly. She also claimed that 2 weeks prior to the trailer being seized, she fell ill and was not able to visit the cats as often, but she also contended that the messy conditions inside the home were a result of the removal of the trailer by animal control officials. Officer Carter entered the inspection of the trailer with a video camera and recorded the conditions inside the trailer. This videotape was played for the jury at trial. All 92 cats were removed from the trailer and assigned numbers for identification. They were also examined and treated by a veterinarian. Her initial summary of the condition of the cats is as follows. Most of the cats were covered in urine and feces. There were many that were malnourished, emaciated. Cats were sick with upper respiratory, herpes virus. They had ear mites, fleas. There were cats with neurological problems. There were cats that were missing portions of their limbs or had deformed limbs. There were cats with urine scald, and there were cats that were either blind or partially blind in one or both eyes, and cats that were missing eyes as well. The veterinarian also described other ailments such as dehydration, chronic malnourishment, anorexia, severe infection, all a result of inadequate care over a long period. It was very obvious to her that these weren't things that popped up over a week or two, but issues that would arise after being neglected for quite some time. There are 2 issues being addressed in these trials. whether the trial court properly instructed the jury on the elements of animal cruelty, as well as whether the trial court properly rejected the defendant's request that she be provided the opportunity to instruct the jury on the defense of necessity. The defendant in this case did acknowledge she had too many cats, but she claimed she was keeping the cats to save them from euthanasia at animal control. So she claimed a defense of necessity, which states that a situation presented to the defendant must be of an emergency nature, threatening physical harm, and lacking an alternative legal course of action. Basically, this is a legal version of just saying that even though you did the crime, you were doing it out of necessity for the greater good to protect something or someone, so that way you can't really be found guilty. The trial court did reject the instruction and denied the defendant's request that she be permitted to present this argument to the jury as a defense. So public policy on how to handle stray animals in California has already been established due to previous cases, and these were used and cited in the trial to uphold the court's decision. So if a stray animal is adoptable or with reasonable efforts could become adoptable, it should not be euthanized. However, if an animal is abandoned and no new owner can be found, the facility shall thereafter humanely destroy the animal so abandoned. So animal control does have the right to euthanize if they cannot find an owner. Particularly, this legislature says that it is better to have public and private shelters pick up or take animals than private citizens. The Food and Agriculture Code provides specifically for what a shelter must do when a stray cat is impounded. Basically, there's a protocol that they have to hold on to this animal for a specified amount of time, sometimes 4 to 6 days. Prior to euthanizing the cat, the facility must turn it over to a rescue or adoption agency if they request. And they also must scan the animal for a microchip within the holding time frame, as well as the veterinarian that is doing the examination upon intake can make the call to humanely destroy an impounded animal despite the holding period if it's medically necessary, if they have any severe injuries or are incurably crippled. In this case, the defendant was charged by information with 7 counts of animal cruelty in violation of Penal Code Section 597, Subdivision B. Count 1 alleged cruelty to all 92 of the cats, while counts 2 through 7 alleged cruelty to one specified cat each. The jury found the defendant guilty of count 1, but not guilty of counts 2 through 7. The court placed the defendant on 5 years of formal probation with a condition that she serve 92 days in county jail. The court also ordered her not to possess or care for any cat or dog except for one particular cat she got to keep named Holly Angel. The reasoning for the jury's decision is because they were instructed the definition of animal cruelty by the court as every person who causes an animal to be deprived of necessary sustenance, drink, or shelter, or who, having care or custody of an animal, subjects the animal to needless suffering, or fails to provide the animal with proper food, drink, or shelter in a criminally negligent manner. In order to prove such a crime, each of the following elements must be proved. 1, that a person has custody or is responsible for providing care to the animal. 2, that person either A, deprived or caused an animal to be deprived of necessary sustenance, drink, or shelter, or B, subjected an animal to needless suffering in a criminally negligent manner. And C, that act or omission caused danger to the animal's life. Because of these instructions, it allowed the jury to find the defendant guilty of animal cruelty for committing either of the act, one, depriving the cats of necessary sustenance, drink, or shelter, or two, subjecting the cats to needless suffering. The defendant did appeal the court decision, so it was seen by Judges Sims and Scotland at the 91st 4th California Court of Appeals at 66. She claimed that the trial was tainted by instructional errors, due process violations, and evidence that should have been suppressed. She also claimed that the court did not instruct the jury properly on how to apply the use of the word "and" in the animal cruelty statute. She claims basically that she can't be found guilty because she did not commit both the first and second parts of the statute. So, for example, if the prosecution had established that the defendant deprived the cats of necessary sustenance, which is one of the acts listed before the word "and," it would also have to establish that the defendant subjected the animal to needless suffering or committed one of the other acts listed after the word "and" in order to obtain a conviction. Basically, after careful consideration of the wording, the argument completely failed. The final disposition in this case is that the defendant is not at liberty to impose her own will over public will. Her assertion that it was necessary for her to keep the cats instead of passing them on to animal control is contradictory to public policy. Because of this, her claim of necessity defense was not really valid since it goes against public policy. The trial court properly denied her request for the necessity instruction and prohibiting her from arguing the defense to the jury. The necessity defense has only been really ever applied to the prevention of harm in humans. The appellate court also found that the statute in question by Ms. Youngblood, the use of the word "and" was irrelevant. By using the word "whoever" as a second subject in the sentence, the legislature effectively lists two separate ways to find a defendant guilty of animal cruelty. That the two lists are joined by the conjunctive "and" that does not convey the meaning attributed to the statute by the defendant. The court concluded the trial court interpreted the statute correctly and properly instructed the jury it could find the defendant guilty of animal cruelty for either one, depriving the cats of necessity, sustenance, drink, or shelter, or two, subjecting the cats to needless suffering. So the judgment was affirmed. I definitely agree with the decisions of the court as well as the appellate court in this trial that the defendant did not take in the cats out of necessity to prevent them from being euthanized, and that she was unable to use that as a defense. I believe that she probably thinks she was doing that, but she absolutely did not follow public policy and do what was best for those animals and what's been established to be the proper course of action to care for them. So I do believe the judge upheld the definition of animal cruelty. The conditions that the cats were in is absolutely deplorable. They had less than 1 square foot of space each. None of them were receiving proper veterinary care. The cats would have definitely been in better hands anywhere else, foster homes, rescues, anything. I thought it was pretty clever that they made her spend 92 days in jail, but realistically, that's only 1 day that she has to spend in jail for 92 lives that she basically ruined, and they could have potentially been rehomed or anything else.